hundreds and thousands of Kenyans lost their life. And yet, to date, nobody who was a perpetrator of that offense was convicted, either in the Kenyan courts or in the ICC. Reason being that there was a bunglement of the prosecution and investigation of those matters. We as Kenyans and as lawyers are alive today how risky hate speech is to this country. Ethnic profiling is a serious offense towards the elections. The elections of 2022 are so emotional that the utterances we are seeing coming from politicians is going to be a recipe for a blood confrontation 2022. The question is, are we dealing with that hate speech properly? In 2007, Moreno Ocampo decided to do things outside the Rome Statute. He investigated matters completely outside the provisions of the Rome Statute. Out of that, a miscarriage of justice was occasioned, and all the Ocampo six, were released and nobody was convicted. Are we seeing the same from the DPP of this country? Already, the DPP has taken Moreno Ocampo approach by invoking wrong sections of the law so that the hate mongers, the moment they'll be charged, like the way Senator Linturi has been charged in Nakuru, the lawyers will simply pinpoint that proper process, due process was not followed, and on technical grounds, all the hate mongers are going to be acquitted. This is premised on this. One, the National Cohesion is an independent body that does not take instructions from anybody. It only starts an investigation by itself, by what is called a suo motu, or two, a complaint launched to the National Cohesion. Two, there are CID officers and police officers seconded to the National Cohesion Commission. Those do not exercise police powers as stipulated in the police standing orders. They take directions from the commission on how to investigate, and the punishments provided for under the National Cohesion are different from the punishment provided for under the penal code, where the police use their powers to arrest and charge. Therefore, the DPP Nordin Haji has no mandate to order the National Cohesion to start investigation. A complaint must be launched. There is no complaint to this effect. Lastly, does the Director of Prosecution have the power to institute commencement of an investigation? The Director of Public Prosecution does not have power, so that when Omari talks here, the Director of Prosecution, DPP, says, investigate him. That is the role of the police. There must be a complaint. There must be an OP. So all these letters that we have seen for the Linturi matter, too bad, Linturi talked badly. Too bad, Onyonka talked badly. But they are going to be beneficiaries of Nordin's mistake by him ordering them to be investigated and ordering them to be arrested. We have been given instructions by our client, one Frederick Bikeri, to move to the Judicial Review Commission, Judicial Review Division of the High Court, which we have done, challenging the decision of the DPP to order the Inspector General of Police to investigate or to arrest. We have filed that matter. We hope that the court will stop that mistake before it exaggerates reaching by September, because we are likely to have bloodshed, because none of the criminal suspects who are going to cause bloodshed in political rallies are going to be charged and successfully prosecuted, by virtue that the due process, as Shadrach puts it, anything outside the due process on technicality, the lawyers will pinpoint to that, and the hate-mongers, those who are causing tension, will go scot-free. So we hope the court is going to stop the DPP and let the police, the Inspector General, and other independent organs like the IEBC, which has powers to investigate on matters election. The Director of Public Prosecution cannot order IEBC to investigate an electoral irregularity. Therefore, he can also not order the National Cohesion to investigate that. We hope the judge is going to give directions, and we hope those two letters, one for Linturi and one for Onyonka, will be quashed, because they completely are out, and his arrogation of powers outside his mandate. That's
core of the judicial review application.
Face camera.
Yes, at the very core of the judicial review application that has been filed today, through the instructions of our client, is that we are calling to question the directive by the Director of Public Prosecutions, directing the Inspector General of Police to investigate matters that are entirely and squarely within the mandate and jurisdiction and the authority of the National Cohesion and Integration Commission. So a reading of the National Cohesion Integration Act of 2008 is quite illuminating. It tells us that the persons with these powers to investigate matters related to hate speech is or squarely lies in the hands of the Commission. Now, this act, the act is unique. It has its unique processes and procedure that are supposed to be invoked in order to avoid situations where we will find ourselves in a situation that we found ourselves in the year 2007. For example, the act itself does not anticipate a rash decision to take a political leader and to take him to court. As a matter of fact, the act anticipates that when a complaint has been done, the commission sits and evaluates as a matter of law whether this complaint can be conciliated. Is there a possibility of ensuring that we have the leader apologizing to the members of the public, so that the people who support him and those that do not support him end up reconciling by looking at the situation quite differently? And that is the proposal, the unique proposal that is proposed in the act itself. Secondly, if the commission arrives at a conclusion that the offense or the complaint is not one that can be conciliated, then the act proposes that the commission can now take a further step. But before we take the further step of prosecuting someone, a political leader, in a court of law, then the law requires that there must be an opportunity of conciliating the differences. So in summary, what we are saying is that the actions of the Director of Public Prosecution, what it does in summary is it makes it meaningless to have the commission as we know of it in law. It makes it unnecessary. It in fact renders it a wastage of public resources for us to be funding a commission that does not exercise its powers as is required in law. So for those reasons, the instructions that we have is that the DPP is overstepping on his constitutional powers. He is overstepping in the powers or the functions that has been donated to him by the statute, and as such, it is proper and right, and it is ripe for the court to arrest the situation, so that we do not have instances where the DPP will be acting in a manner that contravenes the law, which will provide a remedy or a lacuna that will be used by the defense of these people when they are called to book. I hope I have